second lecture on intellectual property. I'm going to talk about IP as it specifically affects the horticulture sector. Hello, my name is Dr. David Monkton, Lecturer Agribusiness, University of Tasmania. I've prepared these lectures with material supplied by Dr. Greg Clydesdale, Senior Lecturer at Lincoln University, New Zealand. In this week's lecture, I'll be talking about plant breeders' rights and registered designs. A key consideration for horticultural plant breeders, especially those who have developed new genetic material and/or means of production, is to protect their breeding rights. What are plant breeders' rights? Plant breeders' rights are exclusive commercial rights to a registered variety of a plant for reproduction, propagation, sale, import or export. An Australian example is Sir Walter Turf, which was developed by Buchanan Turf Supplies Proprietary Limited and registered as a plant breeder's right in 1998. Now that we have introduced you to the idea of ownership, exclusive rights and licensing, we will consider plant breeding rights. Plant breeders' rights are exclusive commercial rights to a registered variety of a plant for reproduction, propagation, sale, import or export. Remember, the new variety of a plant must be distinct, uniform and stable. It also covers seed. It can be combined with other forms of IP, e.g. patents and trademarks, and make sure you do a search of existing PBRs. Someone may have registered it already. Your new plant variety may be distinct, uniform and stable. I am now going to talk about patents and licenses. So you've designed a new product or process for use in horticulture. Should you patent it? In the last lecture, I talked about the different forms of intellectual property. I'm now going to ask whether you really want to use IP protection. Some of the reasons you might want to use it include to stop others using your technology and becoming competitors, to stop others from using technology without paying for it, protect your revenue stream and licenses, to stop others from patenting your invention, then suing you for infringement, to protect a more important invention. Patent variations build a protective boundary around your main invention, and large patent portfolios enhance bargaining power when negotiating finance and cross-licenses. There are other ways of protecting your creation. Some methods include secrecy, lead time advantages, fastest to the market educates market, builds loyalty and locks them in, and complementary assets, e.g. production and distribution capabilities. Secrecy worked for Coca-Cola. More than 100 years later, they still rely on secrecy. However, you will need to ensure your employment contracts include a clause that workers keep the process secret. Another protection is called first mover advantage, in which you are the first to the market and build up a reputation and production expertise with which others can't compete. The last option is more suitable for bigger companies with reliable production and distribution assets, including brand names, which provide a form of protection against competition. However, you should remember that patents have limited effect as protection, particularly in international markets where legal remedies are limited. As a result, there may be a combination of approaches that could be used for equal or better effect. There is no doubt that patents offer protection from people stealing your creation. They protect revenue streams and stop competition. However, the cost of hiring a lawyer and taking legal action against an infringement can be expensive. It is one thing to get a legal right, it is another to actually enforce it. So how do you choose the right method to protect your IP? This will be determined by availability of other forms of protection, ease of reverse engineering, ease of inventing around the patent, close variations of invention, cost of getting patent, cost of prosecuting and enforcing patents, can you afford it? Fear of disclosing too much information in the patent application that competitors can easily copy, a big problem in the software industry. More likely, in venture-based businesses gives security to investors, widespread in high-tech startups. Your choice to use IP protection depends on a number of factors specific to each industry. For example, how easy is it to copy or reverse engineer? Legal costs? Does ownership of IP help you to raise capital? Do you give too much information away when you register? Once you have an effective means of protecting your IP, you are then in a good position to license to others, which increases your ability to reap the rewards. What are the benefits from licensing? They can optimize your position in the value chain. Licensing can increase demand and increase market share, provide for easy transfer of technology to the licensee. Some process technologies are harder to transfer. Reduce the cost of detailed contracts, including how to value the new technology. And once a license is given, you transfer much of the risk of the production, but you also lose control and the opportunity to develop new advancements and markets. If you intend to make money from licensing, you should certainly register. But first, you need to work out if it's in your best interests to license. I mean, if the biggest profits are made in distribution, shouldn't you be there? Of course, if you wouldn't have the distribution facilities, you may have to license others. Just be aware that once you have given out a license, you lose control of some of the supply chain and marketing. There are also general purpose technologies, GPTs, that can be applied to a broad range of applications. For instance, you could buy a GPT license and customize the technology to horticulture, rather than develop the whole technology from scratch. A final point that I want to make is the IP process can go both ways. One entrepreneurial option is to get a license from someone else for a technology that is used in other industries and adapt it more effectively. This meets the need of horticulturalists. Whatever your choice for protecting your IP, you should always be mindful of different methods of achieving your aims, which may be far more profitable. Examples from some specialized engineering firms show that through a downstream combination of licensing and engineering services, they can benefit from learning by doing and repeatedly selling their expertise. Another entrepreneurial option is to get a license and maybe combine it with specialized consulting engineering services. Thank you.